Leader of the proscribed Indigenous People of Biafra, IPOB, Nnamdi Kanu, declined taking plea in court over fresh charges filed against him by the federal government. The federal government had filed fresh terrorism charges against the detained leader of the proscribed IPOB before the Federal High Court on Monday. Consequently, the initial 7 counts bordering on treasonable felony and terrorism against him increased to 15. But during his trial on Tuesday, Kanu declined to take plea on the charges on the advice of his lawyers, who accused the federal government of bombarding them with amended charges. The trial will continue on Wednesday. Meanwhile, human rights lawyer Mike Ozekhome, SAN, is now leading the delegation of lawyers representing the leader of the Indigenous People of Biafra, Nnamdi Kanu. A heavy security presence was observed around the court premises ahead of the trial.
Come out, please. Channels. Do not try, please.
Oh, okay. Come on, carry your piece now. And they acknowledged the miscarriage of justice if they were only given ample time to consult. Where was the charges filed said on them yesterday, sir?
Well, as you are all aware, this is the charge that was filed was dated 17th. That was on Friday, and they filed yesterday. And as soon as it was filed, it was served on them, and they had an interaction with him. And of course, you are aware of the fact that law requires that charges can be amended and filed, even on the eve of the judgment of any case. So the mere refusal to take the plea today is one of the several antics employed by the defendant to delay this case. But I want to assure you that the 3 days given by this honorable court shall be properly utilized, notwithstanding the fact that today has already been frustrated by an act of technicalities. We are ready to take it up tomorrow.
When you say frustrated, who masterminded the frustration?
Of course, the defense.
All right, thank you.
Thank you very much.
You're welcome.
Maybe 1 minute.
And you can see that God was on the throne as regards to these proceedings.
So were you able to conduct your hearing that regards the charges?
Yes, I've now consulted my client, Nnamdi Kanu, as regards the 15-count charge. Some of the statements made by Nnamdi Kanu that were also not clear, which I pointed out to the court. The prosecution has been able to give me another clearer copy, which is legible. And with that, we will take the next step. Tomorrow, no one is running away from plea being taken. But the point we made today, which the court appreciated, is that you can't take plea to counts that have not even been given to you. We were served some minutes to 10 a.m. yesterday a 15-count amended charge for a case coming up today, whereas the last date of adjournment was 2nd of December. So they had well over 1.5 months to have done that and served us. They didn't. So I believe that was intended to frustrate today's proceedings. In any event, that was the 6th time they are amending the charge. Each time they amend, I will file a preliminary objection. They go back to the drawing board to re-amend. So by the time we allow the plea taken tomorrow, by then we would have gotten to the bridge and then we will cross it, because certainly and definitely and absolutely we are going to file preliminary objection to these counts. Many of them are just poor. Yeah.
Yes, and lastly, the judge made some orders, but though as his welfare and his health, though the orders were not enrolled, do you feel the DSS will comply with that order?
Well, the DSS are part and parcel of the democratic organogram we have. I don't think they are aliens from another planet living on Mother Earth here. For the opting time today, the court emphasized to the DSS what they should do. In any civilized society, when you are trying an accused person, give him facilities to defend himself. How do you keep a person in solitary confinement, sleeping on a flat 6 inches bed? I mean, this small student's mattress with no pillow, and expect the person to live a good, healthy life, and he's complaining that he's being stabbed. We put all this in the affidavit. Solitary confinement. You are not allowed to greet any person, to exercise, and when other inmates greet you, they are immediately taken to solitary confinement or to more serious security areas because they greeted you. You are not allowed to practice your Jewish religion. You're sure that you wear, all of them are seized. Well, I mean, the judge had to make another order today. He has been appearing in court all along with the same dress. The dress is not a uniform. It's because he has not been allowed to have another dress. So when you talk about a free and fair trial, all these are what Section 36 of the Constitution is about, when it says a person should be given a free hearing. Free hearing incorporates all this. Free hearing incorporates fair trial. So if, for example, everything is weighted against an accused person and in favor of the prosecutor, then where's the justice? That was the question I was asking the court. The prosecutor investigated. They are the accusers. They are the prosecutors. They are again also keeping custody of the person. Then the person is worn out gradually, psychologically, mentally depleted, psychically traumatized, physically humiliated, and debilitated. In such a case, you cannot say the person is undergoing a fair trial. So these were the points I was emphasizing to the court today, that even though you had made orders again and again and again, these orders are being flouted brazenly with impunity. So this is where we are. I believe that with today's proceedings, there will be a change of heart on the part of the DSS, because the law is that a person should stand trial. The reason they say stand trial is that you should be healthy enough to stand when you are being tried. It didn't say sit trial, or lie down trial, or prostrate trial, or be in a coma trial. Only the living can stand trial. That's what the Supreme Court said. Say only the living can stand trial. In any event, in any case, even convicted persons who are on death row are still entitled to basic fundamental rights. You can't say, for example, that because a person is on death row, then you go there and be flogging him with a cane every day, or you now tell him you can't even practice your religion, contrary to Section 38 of the Constitution. So even a convict has his basic right, not to talk of a person who is presumed innocent under our system of criminal justice, which is Anglo-Saxon based, being accusatorial, meaning your innocence is presumed, not the French model, which is inquisitorial, where your guilt is presumed. And all these have been encapsulated in Section 36 of the Constitution. So I think by the grace of God, we had a good day in the court.
Thank you very much.
Yeah.
Thank you, sir.
Yeah.
Thank you,
Thanks for checking out SYMFONI on YouTube. Please be sure to subscribe and like our videos for updates.